in the manner of Celik and the Secretary of State for Home Department.
Yes.
May it please the Lordships, I and this meeting represent the appellant Mr. Celik. My learned friends, Miss Smythe and Miss Jackson represents the respondent. My learned friends, Mr. Delamere, KC, and Mr. Singh represent the first and second interveners, joint interveners, the Air Centre and Here for Good. My learned friend, Ms. Ward, KC, represents the third intervener, the Independent Monitoring Authority. My Lords, before I go into the submissions, perhaps a little bit of housekeeping.
Yes, certainly.
Your Lordships should have a core bundle.
Yes.
An agreed supplementary bundle.
Yes.
And a short unagreed supplementary bundle. Authorities 1 to 75 in 3 volumes.
Yes.
A brief note on behalf of the appellant.
Yes.
With an enclosure.
Yes.
And
that's the one dated 28th June.
Muggle, correct?
Yes.
And also, and I believe hard copies have been kindly brought to court by my learned friend Miss Smythe.
These are the additional documents.
The Government Legal Department
yes.
An enclosure dated 3rd July 2023.
Yes.
But that was sent by email as well.
Yeah. Okay. Yep.
My Lords, this case raises unique and very important legal issues pertaining to the withdrawal agreement and to Appendix EU. Appendix EU being the immigration rules governing the EU settlement scheme, EUSS, which is the UK's constitutive residence scheme created under Article 18(1)A of the withdrawal agreement. The wider importance of the issues is very clearly reflected in the fact that the court has granted permission for 3 interveners who are represented as I've introduced.
And I assume from where you're sitting that that's the order you're proposing the submissions are made.
Yes,
right?
Indeed, yes. Unless...
Not in height order or anything.
My Lord, no, my Lord, I should say that the appellant and myself and Miss Smeaton and his solicitors are very grateful for the grants of permission for the interventions, and we're very grateful for the submissions and the valuable assistance which the court will receive.
So that is the order in which the...
Yes,
yes. Thank you.
And in very brief summary, I will deal with the appellant's case, grounds of appeal. My learned friend, Mr. Delamere, KC, will deal more extensively with the withdrawal agreement, rule and substance. My learned friend, Miss Ward, KC, will deal with the procedural arguments relating mainly but not exclusively to facilitation.
Right.
That's a very
a
very rough and ready.
So trying not to overlap, but
doing our best not to repeat things that are already before the court. Yes, indeed. The wider importance of these issues is also, of course, because of the intrinsic nature of the appellant's case and others, in that they affect not just the appellants, the applicants under Appendix EU, but they affect inevitably couples, of which one individual is the unsuccessful applicant or appellant, and families. In the appellant's case, he has a wife and a stepdaughter, but there are many other cases, and there'll be other variations on that, obviously. My Lords, I will respectfully take it as read that your Lordships will be familiar with the skeleton arguments, and I will therefore endeavour to proceed in a relatively succinct manner through the issues and the grounds of appeal. So
we have 2 days, so don't feel under any pressure to rush.
My Lord, that's very kind. I guess the pressure might be for me to finish my submissions to allow time for the interveners,
Right,
counsel,
okay.
and also to not repeat myself too much, which is obviously a danger if one allows oneself to go on too long. My Lords, I will outline the nature of the legal problem very briefly. I will take the Court to the material requirements of Appendix EU and to the most important parts of the withdrawal agreement, and I'll explain by reference to those parts of the withdrawal agreement the grounds of appeal and the authorities why the appellant contends that his appeal should be allowed. Last, I will deal with the renewed application to produce the appellant's fresh witness statement, and I would submit that should be looked at in the round in the light of all the other submissions. So,
Yes.
First, the nature of the legal problem. 2, Appendix EU. 3, the withdrawal agreement. 4, the appellant's grounds. 5, the renewed application to produce the appellant's fresh witness statement. The nature of the legal problem before the court can actually be picked up readily from the chronology which the court will have. Yes, that's at pages 3 to 5 of the core bundle.
Sorry, say it again.
That's the chronology.
Yes, okay.
Is at pages 3 to 5 of the core bundle. There are just 1 or 2 minor changes to that. The third entry at the top, the third entry on page 3, the date ending in 2005. The country in question is actually Romania. That's
Right.
That's an error. Nothing turns on that. Proceeding through the chronology, the next key date is the 17th of October 2019. Of course, that's when the final version of the withdrawal agreement was made between the UK and the EU. It's a critical fact, and it's in fact a critical legal consideration. The appellant says that the withdrawal agreement was agreed prior to the eruption of the COVID-19 pandemic. And whilst I'm on the chronology, if I can go to page 4 of the core bundle, the second page of the chronology, there is the date 19th October 2020.
Yes.
That says the appellant made his first application for pre-settled status under the EUSS. That was made, we now know from further information requested by the court that was on the 25th of August 2020. I'm grateful, yes. It's pointed out to me that, the date, the 19th of October 2020, emanates from the certificate of application that the appellant was given in acknowledgement of that application. And going up the page, of course, critically, the 31st of January 2020, the UK's departure from the EU took effect at 11 p.m. GMT. At that time, the withdrawal agreement entered into force in accordance with Article 185, and the agreed transition period commenced, and that would end going down the page, on the 31st of December 2020. I won't dwell on the other dates in the chronology, but you'll see effectively dates concerning for example, 16th of March 2020, the Prime Minister's announcement that everyone stop non-essential contact and travel. Following date, the 23rd of March 2020, the Prime Minister announced the first lockdown. I'll come back to all that, but the chronology will assist the court in seeing the case from the appellant's point of view, seeing the case from the legal position regarding the withdrawal agreement in Appendix EU, and seeing the case from the procedural perspective as well, and overlaying that the entirely unforeseen COVID-19 pandemic. My lords, the withdrawal agreement, which we'll come to, is at tab 47 of the authorities bundle. That establishes the terms of the UK's withdrawal from the EU in accordance with Article 50 of the Treaty of the European Union. Part 2, with which this court will be primarily concerned, protects EU citizens lawfully residing in the UK at the end of the transition period and family members, broadly providing the same rights they had before the UK withdrew from the EU. And it makes similar provision for British citizens and family members residing in member states at the end of the transition period. So a reciprocal, essentially a reciprocal agreement between the UK and the other member states regarding the status of, on the one hand, EU nationals, citizens living in the UK, and their family members and other relevant individuals, and by the same token, British citizens, and the same in the EU member states. So, Article 18 of the Withdrawal Agreement gave the UK and member states the option of creating a new resident status conferring those rights, and that's in Article 18.1. Article 18.1, page 1269 of the authorities bundle before the court.
But it's on the basis that they reside in the territory in accordance with the conditions set out in this title.
It is indeed, and I will come to the interlocking of those preceding articles
Yes.
fairly shortly. But the point is that Article 18 gave the UK member states the option of creating a new resident status conferring those rights and requiring applications to be made on it, a constitutive resident scheme, or of not creating a new status and requiring applications to be made, and simply allowing the status quo to continue. So, by contrast to the constitutive resident scheme, there was the alternative was to allow the status quo to continue, a declaratory resident scheme. Information on which states took which option is at page 289 of the agreed supplementary bundle, which is information from the European Commission. So it's the last document in the agreed supplementary bundle. The UK, sorry, I don't mean to rush it's there, as it were, for the court to see
Yes.
which states decided to do what. But at this point in time, the relevant fact to note is that the UK decided to create a constitutive residence scheme. That was the EU settlement scheme, the EUSS. The statement of intent was published on the 21st of June 2018. That's tab 59. And when it comes to the grounds of appeal, I'll spend a little time on the foreword, but that's the statement of intent on the 21st of June 2018. And Appendix EU was introduced on the 30th of March 2019.
So statement of intent, this is what we will be doing.
Indeed, yes. And you'll immediately note that it predates by quite some time the final version of the withdrawal agreement.
And so you were saying the EUSS was set up March, did you say?
30th of March 2019, yes. And that is the relevant version at the time of the Secretary of State's decision in the appellant's case. That is at tab 58. So, in terms of how things panned out in the appellant's case, and in terms of the issues and the difficulty they pose, it is a question of considering the case from his perspective. He relied, when he made his application under Appendix EU, both applications, on his relationship with his wife, who is an EU citizen with pre-settled status under Appendix EU. Their relationship commenced in February 2020. He proposed marriage in September 2020. This is all in the chronology, but I'm just, as it were, bringing the points to bear on the law, the facts to bear into the law. In October 2020, they gave notice to marry at the registry office. They were, like many other couples in their situation, unable to marry before specified dates, before the 31st December 2020, due to the COVID-19 restrictions and lockdown. They were not, in fact, able to marry until quite a long period of time later, on the 9th of April 2021.
Can I just check that?
Yes.
There were periods of weeks when we were in Tier 3, or when Bracknell was in Tier 3, and there would have been no weddings other than deathbed weddings. There were weeks during the period between proposal of marriage and the 31st of December when weddings could legally take place. But there may well have been a backlog for all we know. But I haven't seen any evidence at the moment about why Bracknell didn't book them in until the date that they were booked in, and what said in the witness statement it was due to COVID restrictions, where COVID restrictions would explain some of the week, but not all of the weeks. And I just wonder whether there's anything else that says, even in the weeks when marriages could lawfully take place in England, Bracknell couldn't accommodate them, or whether there's no evidence.
My lord, yes, I'll deal with that, and that brings me to an important premise on which the appellant's appeal has proceeded. and I'll take you to that first, and then I'll look at refer to the other evidence. So could I take you, and it is very important in light of the court's question, could I take you to page 11 of the core bundle?
Yes.
So, your Lordships will see that's the decision of the first tier tribunal judge.
Yes.
And can I take you to paragraph 3 on page 11? That's the second page of first tier tribunal decision.
Right.
So I won't read out the whole paragraph, but it's salient to observe that this was, as it were, a full appeal hearing in which oral evidence was given by the appellant and his wife and stepdaughter. My learned friend wants me to go to paragraph 12, and I will in a minute, but can I just emphasise that it says clearly at paragraph 3, the appellant's unchallenged evidence is that they decided to marry in September and contacted the Bracknell Forest Council Registry Office on 20th October 2020, receipts in the bundle to give notice of their marriage, and receipt of the same date is contained within the appellant's bundle. However, the appellant's account continues that due to COVID-19 restrictions, they were not given a date to marry before 31st December 2020, having to wait until 9th April 2021. Let's go to paragraph 12. Which, in my respectful submission, cements what I've just said. Paragraph 12. It was agreed that this was a matter to be dealt with by way of legal arguments and submissions. However, Mr. Hawking wished to formalise the evidence that had been placed on file by the appellant in support of his application, and so Mr. Celik, his wife, and his stepdaughter were all called to confirm the contents and truth of their written statements. So the opportunity was there for the Secretary of State to challenge that aspect of the case.
The witness statement simply said COVID restrictions. The witness statement, I think, says checks that they were carrying out and don't say what the checks are. I'm not worried about the COVID restrictions. We can work out the dates from the regulations. Yeah. It's the period when weddings could take place, and they didn't. And that's where I just don't see the evidence at the moment. But I've got your submission, so don't worry.
Yes, well, my lord, there is more on that, because for the purposes of this court's judgment, in my submission, it should proceed on the basis that the appellant's account is not only unchallenged, but well, it's been found by the judge in the first tier tribunal, and as a fact, in my submission, because the evidence was unchallenged. And in the upper tribunal, and I will find the reference, the upper tribunal's decision. The upper tribunal's decision is at pages 18 to 53 of the core bundle. So if I can take your lordships to paragraph 67 of the Upper Tribunal's decision, and that's at pages 46 to 47 of the core bundle.
Yes.
The appellant's case is he would have secured a date for his wedding to take place before 31st December 2020, but for the COVID-19 pandemic. Although there's nothing in the exchanges with the Register Office that confirms this assertion, we should take the appellant's case to its highest and assume that this was so. And in my respectful submission, so should this court. It is a test case. It is a reported decision, and the issues of law should be considered and ruled on in the light of that factual premise. And in response to the point that there may be not a huge amount of documentary evidence on this point, certainly there is the appellant's evidence unchallenged, that of his wife unchallenged. There is the documentation from Bracknell Forest Registry Office. There are the timelines. I won't go to them right now, but the timelines regarding regarding the UK government coronavirus lockdown and measures March 2020 to December 2021, that's at page 117 of the agreed supplementary bundle, and the more detailed coronavirus timeline measures taken by the House of Commons March 2020 to September 2021, that is at page 118. And as we've gone to the Upper Tribunal decision, could I take your Lordships to the second page of that decision on page 19 of the core bundle.
Yes.
And you'll see that those three paragraphs at the top are the head notes of the reported version of the decision in the appellant's case. In other words, as a reported decision, it effectively should be followed by other first-tier tribunal judges and upper tribunal judges, and as I understand, is being followed and applied. And in fact, in my brief notes of a few days ago, I enclosed a copy of the current state of play in the upper tribunal, if I can call it that, regarding the decisions coming out, unreported, but clearly applying that decision. And paragraph 2 it ends. Well, I may just read paragraph 2 out completely because it summarises a kernel of the issues. Where P, the appellant, has no such substantive right, P cannot invoke the concept of proportionality in Article 18(1)(r) of the Withdrawal Agreement or the principle of fairness in order to succeed in an appeal under the Immigration Citizens' Rights EU Exit Regulations 2020. That includes the situation where it's likely that P would have been able to secure a date to marry the EU citizen before the time mentioned in paragraph 1 above, but for the COVID-19 pandemic. And that time is, of course, 31st December 2020, 11 p.m. GMT. So that's the issue before the court, and that's the basis on which the appellant's case has been decided. And if there's any, you have the detailed timelines of various measures during 2020 to 2021, and in addition, there is your lordship's own experience of dealing with cases during those difficult times.
Thank you.
And there are a couple of references to authorities in my skeleton, which I'll come to a little later, that have a further bearing. But that is the agreed factual premise of the case. So just returning to how things panned out in the appellant's case. The appellant made his first application under Appendix EU, as I've explained and clarified, on the 25th of August 2020, and that was long before the specified date of the 31st of December 2020. But that wasn't decided, that application wasn't decided by the Secretary of State until the 2nd of March 2021. That decision, and I don't think we need to go through it at this point, it's at pages 14 to 16 of the agreed supplementary bundle. It was refused on that date because although the appellant had stated he was a durable partner and provided documentary evidence, that's put beyond doubt by the materials that the Secretary of State provided. So the decision itself, the decision of the 2nd of March 2021, makes it clear what the basis of the application was as a durable partner. Documentary evidence was provided, but it was refused because the appellant didn't have a residence card issued under the EEA Regulations. Obviously, a legal issue that we'll have to come back to, but that was the first application under Appendix EU.
Could that decision have been appealed?
I suppose it could have done. I anticipate that it was not, because by this point in time, the appellant was going to be married in a few weeks.
The letter says it could have been appealed. It may have given the wrong provision, but the decision letter does say that it was subject to administrative review or appeal within 14 days, 28 days for administrative review or appeal within 14 days. It may have given the wrong source of the appeal, right? But he was told he could appeal and he didn't appeal.
Well, perhaps
Are you looking at the decision letter? Or?
yes. It's 14 to 16 of the
15 next steps.
Yes. Ultimately, for reasons which will be explained, the appellant will submit that it doesn't matter that he didn't appeal that decision. From a purely human perspective, he knew that he was about to get married in early April 2021, and there was the option of therefore making an application based on the fact of marriage. Well, yes, I've been asked to point out, and I'm grateful that as far as the appellant was concerned, on the basis of that decision, he couldn't succeed on appeal.
Because
if we go to page 14 of the agreed supplementary bundle, the penultimate and last paragraph, you state you are a durable partner of a relevant EEA citizen. However, you've not provided sufficient evidence to confirm this. Reasons for this are explained below. The required evidence is a valid registration certificate, family permit or residence card issued under the EEA regulations.
Whether or not that was correct, do we have to proceed on this appeal on the basis that that decision on the 2nd of March 2021 was unchallenged and therefore it is not under appeal before this court?
That's a knotty question. That's a difficult question, and I don't say because there's not an answer. I say because the answer is nuanced and somewhat complicated,
Right.
and it depends on whether.
But don't take your submissions out of turn.
No, but I'm here to assist the court.
Come back to this point,
Yes.
by all means,
Yes.
and give us the more nuanced answer.
Yes.
So it's not necessarily safe to proceed on the assumption that this must be taken as a valid decision.
No, absolutely not. Absolutely not. So the appellant made his second application under Appendix EU on the 17th of March 2021. His marriage certificate from his marriage on the 9th of April 2021 was uploaded on or about the 12th of April 2021, and that was before the Secretary of State when she made her decision. And the Secretary of State again refused the appellant's application on the 23rd of June 2021. And that is at pages 6 to 9 of the core bundle.
I'm sorry, which page?
Pages 6 to 9 of the core
Oh,
bundle.
629, sorry.
The page numbering might be a little bit difficult to see on this document. It's not too far into the bundle, and the electronic numbering would be the same. So 6 to 9.
Yes, I noticed it says 18 at the bottom, but don't worry, I have it now.
So if we can go to page 7. You've provided a marriage certificate dated 9th April 2021 as evidence that you're the spouse of an EEA citizen. However, you have not provided sufficient evidence that you're a family member of a relevant EEA citizen prior to the specified date, as defined in Annex 1 of Appendix EU, i.e. 2300 GMT on 31st December 2020. Your marriage certificate shows your marriage took place on the 9th of April 2021. It then went on to consider eligibility under Appendix EU on the basis of durable partner. But again, in almost identical wording that we've already seen in the previous decision, the required evidence of family relationship for a durable partner of a relevant EEA citizen is a valid family permanent and residence card issued under the EEA regulations.
Yes.
So the appellant's case was refused because it was not, and the appellant says, not simply not, he was unable to get married to his wife prior to the specified date. So he was not married prior to the specified date, and he didn't have a residence card issued under the EEA regulations. The Secretary of State's decision was upheld by the first-tier tribunal judge's decision that we've already looked at, dated the 6th of January 2022, and it was upheld on further appeal to the upper tribunal on the 19th of July 2022, and we've already touched on both those decisions. And I have, as it were, in response to questions from the court, I've highlighted the critical facts and procedural premise of the appeal, that the appellant's evidence about being unable to get married prior to the specified date, due to COVID-19, the pandemic and the restrictions, is unchallenged. And there are many other cases where this issue arises. So this case was decided by the upper tribunal to deal with those cases.
Mr. Hawking, can I just take you back for a moment, please?
Yes.
To what I think is page 7, the core bundle.
Yes.
I just want to understand, if I may, with you, that I've understood correctly the structure of the reasoning in this decision. It appears that there are two reasons given. The first is contained in the first two paragraphs and is to do with the marriage issue, and essentially is saying your marriage took place after the relevant date. Have I understood that correctly?
This is page 7 of the core bundle.
Yes.
Yes.
So that's the first reason. It's to do with marriage. Now, as I understand it, your submission about how COVID delayed the date of marriage is relevant to that issue. Is that right?
Yes.
But the decision then goes on to say, therefore, consideration has also been given as to whether you meet the requirements as a durable partner. And then the following 3 or 4 paragraphs address that. And as you've informed us, the words used in those 3 or 4 paragraphs are almost exactly the same as the ones which appeared in the 2nd of March decision earlier. But if I understood your submissions correctly, that you also challenged that second alternative set of reasons.
Yes. So the facts of the appellant's case, as we've gone through them, explain the nature of the legal problem before the court. There's a very significant cohort of individuals like the appellant who had intended to and attempted to marry their EU partner before the specified date, but were unable to do so until after that date had passed due to the COVID-19 pandemic and restrictions. And because they didn't have a residence card under the EEA regulations either, they've all been refused pre-settled status under Appendix EU. But for the pandemic, on the accepted basis on which the appellant's case has been considered, but for the pandemic, they would have that status if they had been able to marry before 31st December 2020. They would automatically be family member of an EEA citizen and therefore be given status under Appendix EU. So that is the characteristics of the group before of the appellant's case and many others like it. The other feature which we've seen as well in the appellant's case is that he had applied under Appendix EU prior to the specified date, but was refused after that date had passed on the basis he did not have a residence card. There are a number of documents before the court explaining that there are numerous cases of this kind, and can I take your lordships to pages 112 to 113 and 114 to 116 of the agreed supplementary bundle.
Which pages?
112 to 113.
Yes.
So 112 to 113 is the letter of ILPA, the 3 million in here for good,
Yes.
dated 7th of January 2022, the Minister for Immigration. And I'll just ask you to look at the bottom of page 112. There's a heading there, marriage, civil partnership, delayed due to COVID-19. And that refers in the first 4 words to there are numerous cases. And worth looking at page 113. There's a recommendation there urging the Secretary of State to provide a concession for those individuals. It says EEA nationals who've not been able to marry enter into a civil partnership before the end of the transition period due to the impact of COVID-19 should not be left in a worse position than those who were married with their spouses entered into a civil partnership prior to 2021. In these circumstances, the effect of the requirement that durable partners must have been granted an EEA residence card is discriminatory.
Why is it discriminatory? Does that mean unlawful discrimination or just different?
Well, my lord, it's effectively multi-layered in this case, but it comes down to the fact that insufficient consideration has been given in legal terms to the reasons why this group of individuals have been shut out of Appendix EU, and that's when we'll have to look at the withdrawal agreement. But we say that the discrimination is multi-layered and nuanced.
But is it unlawful discrimination contrary to a provision of law, or is it a word to say this isn't fair?
Well, we'll in due course explain that it's both. But
Both.
you know,
Unfair and unlawful discrimination.
there is also the letter at pages 114 to 116. And can I just take your lordship? That's another letter from the same organisation, dated the 7th January 2022, and this is to the head of Euro and Settlement and EU Settled Status Customer Resolution Centre. And I'll ask your lordships just to read the passage at the bottom of page 114.
Yes.
We're aware of numerous cases where durable partners applied prior to the end of the transition period. However, rather than using the application form, the residence card under the EEA Regulations 2016, they applied for status under the EU Settlement Scheme. Page 115 at the top. This cohort of applicants clearly intended to apply for confirmation and protection of their rights of residence under EEA Free Movement Law and the Withdrawal Agreement. We understand that the reasons for applying directly under the EU Settlement Scheme included that even where people were legally represented, it had not been appreciated, given the complexity of the pre- and post-Brexit transition period provisions, that durable partners were required to first apply for a document under the EEA Regulations by 31st December 2020. I won't read out the rest of that. You have the recommendation at page 115. Yes, I've been asked to take the lordships as well, and I'm grateful to the bottom of page 115. Can I give your lordships a moment just to read the rest of that page and then...
Okay.
Sorry.
Yes, thank you.
So the final paragraph at the bottom of 115 going on to 116.
Yes.
Alternatively, it is our view that the Secretary of State for the Home Department ought to exercise her discretion under Regulation 21.6 of the EEA Regulations 2016 and disapply the requirement to have used the specified application form. Regulation 21.6 provides the important safeguard that where there are circumstances beyond the control of the applicant, the Secretary of State may exercise discretion over whether to accept an application under the EEA Regulations 2016 or not, on the basis that neither the Home Office website nor the EU Resolution Centre, when directly asked, warned people in these circumstances of the requirement to apply for a residence card under the EEA Regulations 2016. First, the requirement ought to be disapplied. And that assists the court in response to the question from my Lord Justice Singh regarding the first decision in this appeal, the first refused application under Appendix EU.
Well, these two letters,
Yes.
which you've shown us, are on behalf of NGOs rather than individuals. And so, if I can use the phrase macro level, that they're really asking the government to do certain things, possibly in the exercise of discretionary powers, because discretion is mentioned, at a macro level. In other words, that they wouldn't just be in favour of any particular individual. They would disapply, for example, certain requirements generally.
Yes.
How did the government respond to that request at a macro level? I mean, forgive me if don't take it out of turn.
My Lord, I'm grateful for the intervention because it allows me to
only if it's convenient
deal
for you to
with
take
the
it.
issues directly. Well, my Lords, can I take you to pages 110 to 111?
In the same bundle.
Yes, indeed. So going.
Right.
Can I let your Lordships read that? It's a short letter, and then I'll briefly make my point. Well, my Lords, I would draw particular attention, even though it's a short letter, to the penultimate paragraph on page 110, where they were in the UK unlawfully before the end of the transition period. It would not be appropriate to enable them to remain in the UK by simply applying to the EUSS. Sorry, I should have just clarified because I appreciate that we have people listening to the proceedings. This is the minister's, the immigration minister's reply dated February 2022. There was no more specific date than that. So the response is, where they were in the UK unlawfully before the end of the transition period, it would not be appropriate to enable them to remain in the UK by simply applying to the EUSS, as this would reward them for not complying with the requirements for a lawful basis of stay this would also penalise the many EEA citizens and their durable partners who complied with those requirements, including where the partner remained overseas before the end of the transition period, or where the couple made arrangements to marry overseas before then, rather than choosing to reside in the UK unlawfully. So that's durable partners in the UK without a residence document. And then the second heading on page 111.
The other thing to bear in mind before you leave that is
Yep.
the way we know whether or not a person is indeed a durable partner is because the government have decided that their evidence is good enough and they've issued a residence document.
Yes.
There's one issue, should they just rely on that? But as to whether or not somebody is a durable partner, you do need a decision in some form from the relevant authority saying that, yes, you're in the same house and you are in a relationship,
Yeah.
and that relationship is durable.
Yes, my lord.
Not like marriage, which you can look at the certificate.
Well, my lord, if I may say so, that encapsulates the unusual collision of factors in this case. It is, of course, right that the issue of a residence card as a durable partner follows on from a consideration by the Secretary of State of evidence. That's clear. But the question for the court is, in what circumstances can that consideration be made?
Yeah.
Does it have to be an application under the EEA regulations?
Yes, that's the question.
If in substance it is an application for a residence card or for recognition under EU law as a durable partner, is it not enough that it is an application by another route, such as Appendix EU, the EU settlement scheme? The more so if evidence has been provided. And I'll keep going with the submissions, but I respectfully observe that a significant part of the Secretary of State's case has fallen away with the further information that's been provided to the court. Because in the first application, which was made well before the specified dates,
25th of August.
25th of August 2020, acknowledged on the 20th of October 2020, refused on the 2nd of March 2021. But it does seem clear from the documents from the Secretary of State, and I'm grateful that they've been put before the court, that not only did the appellant say I'm a durable partner,
They put forward
provided
some material
evidence.
which they said supported it. But there was
Yeah.
a decision that, rightly or wrongly, on the wrong legal basis or the right legal basis, that they didn't qualify, and there was no appeal. So there's never been a decision that they qualified as a durable partner. That's the position, isn't it?
well, my lord, that reinforces the appellant's case. The consideration of the evidence that the Secretary of State has said in her skeleton argument before the court, the consideration of that evidence that she said was needed has not taken place. The evidence was before the Secretary of State. That's what the latest, that is what the further documents make very, very clear. So to go back to my Lord Justice Singh's question, the status of that first refusal decision, it's pending a lawful decision on that.
It's had a decision and you haven't appealed it. Whether it was unlawful or not, we never know.
My Lord, I'd respectfully disagree. It really depends on which prism one looks at that application through. And if it's through the prism, as we'll go on to look at shortly, if one looks at that decision through the prism of the withdrawal agreement, it's an application for facilitation and is pending a lawful decision on that basis. But that's in
You're going to come to that, yes.
We will come to that, and I will do my best not to keep the court in too much suspense in terms of getting into the legal arguments. But a lot of this is necessary background setting, legal contextualization. It's a very complex mix of different laws and a complex mix of facts, both relating to the appellant and external factors and forces beyond his control. So could I just say a word about the second paragraph, sorry, the second heading of the Minister's letter on page 111. So where the spouse, the heading is marriage or civil partnership delayed due to COVID-19, where the spouse or civil partner of an EEA citizen resident in the UK before the end of the transition period is concerned, they will be eligible for the EUSS where they're themselves an EEA citizen and can rely on their own residence in the UK by 31st December 2020, or where the marriage or civil partnership was formed after this date, and in line with the requirements of the Free Movement Directive and the Citizens' Rights Agreement, the couple were durable partners by this date. Any impact COVID-19 may have had on the timing of the marriage or civil partnership does not affect the scope for a non-EEA citizen to have obtained or applied for a relevant document as a durable partner under the EEA Regulations before the end of the transition period in accordance with those requirements. I won't read out the rest, it's a short letter. The Secretary of State's response in my submission was expressed in polite terms: hard luck, tough luck.
It's basically saying no.
Yeah.
In a word, it's saying you've made these various requests, and the answer is no.
Yeah.
And again, please don't take this out of turn. But what I'd be interested to know is, was that answer no challenged by way of judicial review, for example?
To my understanding, no. In all of these cases, there's the statutory right of appeal, and of course, judicial review is a remedy of last resort.
No, I understand that, but these are NGOs which
Yes.
were asking not for individual decisions
Yeah.
in favour of any particular person, but a macro level
Oh,
change.
I see.
Either a concession should be
Yes.
introduced or some discretion should be exercised. And my question is simply, did anyone, for example the NGOs, challenge the answer, no, I'm not going to do that?
I obviously represent the appellant, and I won't know all the
No.
well, I won't know all of. To my understanding.
Can I help with that question?
Can I help? Since it's my client who wrote
Is your client, actually?
it's my client that wrote the letter. There has been no challenge based upon the macro general issues of discretion, like you should grant a concession. The reason I was astute to rise earlier is, of course, there is a complaint about the effect of Regulation 21, which is applied in every case, has been applied in this case, and that is the focus of the challenge now. And it's a challenge that may be properly brought in the context of an individual case.
Could I just rise and confirm that not only did Mr. Delamare's clients not make any complaint, nor did anybody else, and as I understand it, not even by pre-action protocol letter, let alone an actual claim.
Yes, I mean, I was only asking a factual question. Whether it has any legal significance, I have no idea.
Yes, well, my lord, putting matters in a very brief way on behalf of the appellant, what the appellant submits is that the Secretary of State's approach to his and all these cases, I can say all these cases because of these letters before the court, not only is the folded arms no response plain to see, but what's equally plain to see is that the Secretary of State, Minister, mischaracterised the issues about which complaint was made. So it's simply not the case. Looking at page 110, that by considering an application under the EUSS made in a timely fashion, as it was in many of these cases before 31st December 2020, simply not the case, is it, that to look at such an application in a purposive way, considering the material, considering the application and any material in light of the EEA regulations, is simply not the case. That to do that would reward them for not complying with the requirements for a lawful basis of stay. The appellant the court may think did his utmost to comply with the requirements for a lawful basis of stay, and frankly the Secretary of State in his case took her merry time looking at that application. Over 6 months, if I have my arithmetic right, 6 months or thereabouts, to say no, you needed to apply for a residence card. Coincidentally or unfortunately,
not only that, when he did or she did finally tell him, it was too late to apply for a residence card.
Well, indeed,
they weren't available.
Yes, my lord. But that's the point in the appellant's case, and the many like it. It is not simply a question of the Secretary of State's stance to these cases being one of no. It is a question of that no being premised on a mischaracterisation and a misunderstanding of the issues that have been put. And by the same token, how would looking at an application made under the EU settlement scheme prior to the 31st December 2020 in a purposive way, how would that penalise the many EEA citizens and their durable partners who complied with these requirements, including where the partner remained overseas for the end of the transition period? I won't read on, but what? And then it goes on, rather than choosing to reside in the UK unlawfully. Well, I've dealt with the unlawful point. If someone is making an application to the Secretary of State, they are seeking to comply with the requirements for a lawful basis of stay. And yet, this requirement is so important to the Secretary of State that she took 6 months to refuse the appellant's application. And of course, when we look at page 111, the error in my submission is repeated in the paragraph at the top of 111 under the heading Marriage or Civil Partnership Delayed due to COVID-19. And the court may take the view that there is a singular failure or refusal to acknowledge the impact of COVID-19 on this appellant and this group of cases, these individuals intending to get married but unable to do so due to COVID. Some, many perhaps not all, but some of those as an alternative applying under the EU settlement scheme but being refused, applying before 31st December 2020, but being refused on the basis they don't have a residence card, not being refused until the clock has struck, until after the clock has struck 11 p.m. on the 31st December 2020. The Secretary of State has singly failed to recognise and acknowledge the very real difficulties that this group of individuals had due to COVID and all its associated effects. And certainly in the case of someone such as the appellant who'd applied under the EU settlement scheme before 31st December 2020 as a durable partner with evidence. It is difficult to see anything in this letter that justifies that as defensible reasoning supports the Secretary of State's stance. There's mischaracterisation and there's false comparisons. This situation was not of the appellant's making, and it was not of the making of the many others like him. They would, if 2020 had been normal, they would, in the course of that year, have been able to marry, and they would have automatically been family members of EU citizens. And alternatively, if the Secretary of State, alive to the difficulties posed by the COVID pandemic, had she taken a purposive and we say withdrawal agreement compliant approach to applications under the EU settlement scheme, they would have at least had a consideration of their circumstances as a durable partner, which would have resulted in a residence card in very many cases. Well, my lords, I won't take up more time on those letters, but they do in their way, do they not, bring to the fore the battle lines,
Right.
in terms of the issues.
Does that bring us to the next stage?
In fact, what I would submit is that those letters demonstrate that, as well as a legal issue, because of the many refused applications and appeals proceeding through the first-tier tribunal after tribunal, it's a complex human problem, and the appellant respectfully submits and doesn't shy away from this point. It's a weighty moral. It has a weighty moral dimension, which the Secretary of State has been unable to see or acknowledge or cater for, and it has a weighty moral dimension. For the reasons I've said, the marriages would have been taking place as normal were it not for COVID.
I think we have got that.
Yeah, and of course, there is the impact on partners and children and other
Yes.
family members.
Yes.
Can I go to the statement of intent and look at that for just a few minutes? That should be tab 59.
Yes.
So if I can take you to pages, so that's 59 of the authorities bundle, page 157 to 1578 to 1579 is the foreword by the then Home Secretary.
Yes.
I'm just going to briefly deal with this. The foreword is by the Secretary of State at that time, as I've said. First para on page 1578. EU citizens living in the UK, along with their family members, will be able to stay and continue their lives with the same access to work, study, benefits and public services that they enjoy now. Existing close family members living overseas will be able to join them here in future. The last three paragraphs, this is introducing the EU settlement scheme, the last three paragraphs.
Yes.
This is the process. The process, to make the process as simple as possible for the great majority of EU citizens, we will check employment and benefits records of permanent residents. Applicants who wish to submit additional evidence will be able to provide a wide range of documentation, as the appellant did. in both applications, reflecting the variety of people's individual circumstances, and they will generally be able to upload scans or photos rather than sending us hard copies. This is critical, this next paragraph, the appellant says. Throughout, we will be looking to grant, not for reasons to refuse, and caseworkers will be able to exercise discretion in favour of applicants where appropriate to minimise administrative burdens. That reflects an important part of Article 18 of the Withdrawal Agreement, which we will come to. And then at the top of 1579, EU citizens and their family members do not need to do anything immediately. There will be no change to their current rights until the end of the implementation period on 31st December 2020, and the deadline for applications to the scheme for those resident here by the end of 2020 will be 30th of June 2021. And in my submission, it's an important thought as to how EU citizens and their family members and other relevant members.
Well, that's the question. You say family members and other relevant members. The question I was going to ask you is,
right.
Are family members defined? Because in EU law, they're normally defined in a very close way. And then there's an additional category of people who are not family members, brothers, sisters, and durable partners. And I just don't know whether this foreword is addressing those people or whether it's not addressing those people.
Well, it's the foreword, and it's the appellant submits that this is the general message that goes out to all EU citizens, close family members, wider family members, durable partners. This is the general message that went out, and it's effectively a message of this scheme being very simple, straightforward, generous, looking to grant, not for reasons to refuse, exercise of discretion in favour of applicants where appropriate, minimisation of administrative burdens, and the message at the top of 1579, no need to do anything immediately. There'll be no change to their current rights until the end of the implementation period on 31st December 2020, and the deadline for applications to the scheme for those resident by the end of 2020 will be 30th of June 2021. So it's a matter for the court, of course, but it may take the view that this, the way the EU settlement scheme was introduced was in a very arms open, we're here to help.
Well, that may be right, but what it does clearly do
Yep.
is lay down some deadlines. And they are very clearly, expressly set by reference to calendar dates. Everyone knows those are the deadlines. Does your submission on this appeal in effect amount to saying, well, those deadlines didn't really constitute hard deadlines in law?
Well, that's a very good question, I would submit that when it will come to looking at the withdrawal agreement, what will be critical will be to look at the provisions on the scope for EU citizens and family members and partners and so forth, and the procedure of the residence status, the constitutive resident status. But in my submission, that there is ample material, ample provision in the withdrawal agreement for flexibility, particularly if there are wider circumstances beyond the control of the appellant or applicants like him, which, if are not properly taken into account by the means available to the Secretary of State and to the tribunals, will confound the principles of the withdrawal agreement.
Anything else in this?
Well, I will now proceed to look at Appendix EU.
I'm so sorry,
Sorry.
to stand up, but before my learned friend moves away from this document, could I take the court to quite an important section that it hasn't been shown? It begins at page 1599, and it's misleading to look at the forward without looking at this section.
Oh, yeah.
Section 6, what family members will be eligible for the scheme? And could I ask the court that whole section is relevant, but could I ask the court to turn to page 1601? There's a section which says durable partner, and it makes clear that the relevant document needed to have been applied for by 31st of December 2020. So I'm sorry to interrupt Mr. Hawking, but to save us coming back to that document, I'm grateful.
Yes, thank you.
My lord, it's right from a learned friend, Miss Smythe, to point that out. Of course, the point that the appellant makes is it's the overall message of the statement of intent that should be considered, and whether or not an individual in the appellant's position or others like him are going to be able to read and understand the relevant rules and guidance is something that the court would have to consider. The thrust of the scheme is looking for reasons to grant, not for reasons to refuse, and assisting appellants.
Yes.
Yeah. So
Going to the
Appendix
settlements.
EU.
Yes.
So this is tab 58, and it's relevant to look at EU 11,
Sorry, what page is that?
sorry, did I not say? Page
Oh, so it's EU 11.
Yeah,
Yes.
1505.
Yes.
That should be.
Yes.
And so that is persons eligible for indefinite leave to enter or remain as a relevant EEA citizen or their family member, or as a person with a derivative right to reside or with a Zambrano right to reside. So that's EU 11. That results in what's called settled status
Yes.
under the scheme, which is another way of saying indefinite leave to remain. And then can I take you to 1512? And that's eligibility for limited leave to enter or remain.
Yes.
EU 14, paragraph EU 14.
Yes.
Persons eligible for limited leave to enter or remain as a relevant EEA citizen or their family member, and so forth. And the applicant, and this is clear from the first tier tribunal, the appellant in this case, and many others, would have been relying on condition 1. Family member, the applicant is 1A. The applicant is a family member of a relevant EEA citizen, and B, the applicant is not eligible for indefinite leave to enter or remain under paragraph EU 11 of this appendix,
Yes.
solely
Yes.
because they've completed a continuous qualifying period of less than 5 years.
Yes.
Right, now, my lords, I suppose in a sense I was putting off the evil point at which I would have to take you through Annex 1.
Well, the first question is, who is a family member?
Yeah, well, yes, indeed.
Right. Well, Okay. Which page?
Page 1533.
Thank you.
You'll see how long and complicated this rule is. The rules in Appendix EU with Annex 1, it's a very long and complicated piece of legislation in my submission.
So which, do you want us to take us 1.5?
Yes, so
3.3.
family member of a relevant EEA citizen.
Yes. Durable partner?
Yeah.
Yes.
So it's the spouse or civil partner of a relevant EEA citizen, and the marriage was contracted, or the civil partnership was formed before the specified date. We've been through that.
Yes.
Or the applicant was the durable partner of the relevant EEA citizen before the specified date. The definition of durable partner in this table being met before that date rather than at the date of application, and the partnership remained durable at the specified date.
Yes.
And you'll see in that rule effectively how being a spouse and durable partner are alternatives that can be looked at in the same application. And you'll see from the way it's worded that if the marriage was contracted after the specified date as opposed to before the specified date, then the appellant has to rely upon little Roman 2, the alternative. The applicant was the durable partner
Yes.
before the specified date.
So looking at your spouse point, is your submission that you can't qualify under the EUSS Rule 14 as a spouse? You may or may not be able to qualify under the EU Withdrawal Agreement, but you're not submitting, are you? Or are you submitting that you can satisfy the rules and there's been a misapplication of the rules on spouse?
My Lord, another very apt question. It would require a very purposive reading of the rule.
So where it says the marriage was contracted before the specified date, it means before or after the specified date?
Well, that's it would. I will ask you to consider the submissions about
Okay.
how to read the immigration rules, but that's not at the. It's fair to say it's not at the forefront of the appellant's case, and the appellant's case was refused on the basis that he didn't meet the rule, and that wasn't the thrust of the case in the upper tribunal. If that
Yes.
assists. And so we then must go to the definition of durable partner.
Yes.
It's 1527.
Yes.
So A, the person is, or as the case may be for the relevant period, was in a durable relationship with a relevant EEA citizen, or as the case may be with a qualifying British citizen or with a relevant sponsor, with a couple having lived together in a relationship akin to a marriage or civil partnership for at least 2 years, unless there's other significant evidence of durable partnership. And B1, the person holds a relevant document as the durable partner of the relevant EEA citizen, or as the case may be of the qualifying British citizen, or of the relevant sponsor for the period of residence relied on, for the purposes of this provision, where the person applies for a relevant document as described in subparagraph A1, AA, or A2 of that entry in this table, as the durable partner of the relevant EEA citizen, or as the case may be of the qualifying British citizen, before the specified date, and their relevant document is issued on that basis after the specified date, they're deemed to have held the relevant document since immediately before the specified date.
Yes.
That is a considerable mouthful to have to digest, but the thrust is that one has to be in a relationship akin to a marriage for at least 2 years, unless there's some other significant evidence, and have the residence and hold a relevant document.
Yes. Yes.
So I'm just being assisted by my religion. Well, could I respectfully ask your lordships just to read Can I ask your lordships to read a little further into that, to just
Right.
see how complicated the
Yes.
provision is?
So it's subparagraph 2.
Yes,
That is.
yes, that's the alternative.
Any particular feature that you want us to look at? Was it?
Yes, triple A.
Yes. So this is if you don't have
Yeah.
a relevant document,
Yes.
and but it's applying to people who at some stage or other in the process were not resident in the UK.
Yes. Well, that's one reading. But as I alluded to in my skeleton argument, that provision's been described as very difficult to really understand and make sense of.
But how do you say it's relevant to your case?
Well, my lord, as we're on the definition of durable partner, I've just asked you to look at the
full definition.
the full definition,
Right.
to see that on the face of it, it's densely worded, it's tightly packed, it's difficult,
I see.
even for experienced immigration lawyers and judges to understand.
This would only cover the second application, would it? The date of application is after the specified date, and the person was not resident in the United Kingdom or Islands as the durable partner on a
Well-
basis which met the definition of family member.
My lord, the appellant's case proceeded on the basis that he didn't meet the requirement of durable partner in Appendix EU, which we've gone to. But effectively, I was seeking to convey the very real difficulty of many individuals concerned with these cases of precisely understanding the rules and what they mean and their impact, it is a factor.
But we do need to understand it, I think, because this looks as if it might help your client if they made an application afterwards and they couldn't qualify before because they didn't have residence on the basis of a relevant document. And that seems to be saying the Secretary of State is satisfied by evidence provided by the person that the partnership was formed and was durable before the specified date. And that might, I'm not suggesting it does, I'm saying that might be an alternative way, which hasn't yet been argued by anyone, for saying the second part of the second decision was unlawful. But
Yes. Well,
unless we help to understand this paragraph, and then, or unless you say that it's not actually the paragraph that you're relying on as helping you to challenge the second part of the second decision, whenever it was June's decision.
The view seems to be that despite its difficult wording, that it's for out of country.
Yes.
So it's to bring people in, not those who are here unlawfully.
That may be right, but it's a very difficult part of
But what I need to know is, although it's very difficult, is your submission that your client falls within it, falls without it?
The case has not been argued on that.
Right, so not argued on the basis that meets.
Thank you. It's part of your case that it's all is not clear, confusing.
Yes, indeed, and that view is supported by, and I'll just.
No, don't worry about that.
It's referred
Yeah.
to in the skeleton argument.
So
the view.
that's durable partner. Any other provision in this scheme?
No. I mean, one sees it's a very long and complicated piece of legislation, but the first tier tribunal and the upper tribunal decided that the appellant didn't fall within it. So, for completeness, the definition of the specified date is at 1571. Yes. So specified date at 1571.
Yes.
And been asked to take you to the definition of relevant document at 1546, and that's right.
1546.
Yes.
Yes. Yes.
So, in terms of an appellant's appeal options in these circumstances, there's a right of appeal to the first tier tribunal, and the grounds of appeal are either that the decision is not in accordance with the immigration rule, or that it is contrary to rights under the withdrawal agreement. Obviously, as I've explained, Appendix EU is the UK's constitutive residence scheme under Article 18.1 of the Withdrawal Agreement, and because of the appeal scheme permitting an appellant to rely on rights under the Withdrawal Agreement, even if they don't meet the definition of family member, of spouse, of durable partner in Appendix EU, they can rely upon their rights under the withdrawal agreement, and so it's the withdrawal agreement that we go back to, and that's at tab 47.
Yes.
And again, a very long and complex document. Not all of it's before the court because not all of it needs to be. But if I can take you very quickly through the critical parts of the withdrawal agreement. And as you'll see, you have the recitals on page 1260.
Yes.
So the first recital refers to the UK's sovereign decision to leave the EU. And of course, that's a given.
And reciprocal protection at the bottom.
Yes, but yes, absolutely. It is necessary to provide reciprocal protection for Union citizens and for UK nationals, as well as their respective family members, where they've exercised free movement rights before a date set in this agreement, and to ensure their rights under this agreement are enforceable and based on the principle of non-discrimination, recognising also that rights deriving from periods of social security insurance should be protected. There is also 5, and that refers to the objective being to ensure an orderly withdrawal.
Yes.
And in my submission, although relied on heavily by the Secretary of State, the principle of an orderly withdrawal, that assists the appellant more strongly, because the appellant will respectfully submits that his situation and the situation of others like him is heavily symptomatic of a disorderly withdrawal with regard to the citizens' rights provisions as relied on by himself and the other applicants. And the 7th recital is at the top of 1261.
Yes.
Again, reference to an orderly withdrawal aiming to prevent disruption and to provide legal certainty to citizens and regulators, as well as judicial and administrative authorities in the Union.
Yes.
The 14th recital, the agreement is founded on an overall balance of benefits, rights and obligations for the Union and the UK.
Sorry, where's that?
Sorry, that's the 14th recital, 3 from the bottom of 1261.
Right, yes. Yes.
Can I take you to Article... Sorry. Can I take you to Article 4?
It's quite useful to see the structure as we go. You've
So-
got Part 1 first, which is common provisions, and then you'll have different parts and titles within parts. It's quite useful to remind us of those as we go. So we're into Part 1, common provisions at the moment.
Yes.
And you want us to look at?
Article 4. Article 4, methods and principles relating to the effect, the implementation and the application of this agreement. 1. The provisions of this agreement and the provisions of Union law made applicable by this agreement shall produce in respect of and in the UK the same legal effects as those which they produce within the Union and its member states. Accordingly, legal natural persons shall in particular be able to rely directly on the provisions contained or referred to in this agreement which meet the conditions for direct effect under Union law. And in actual fact, the agreement is, the withdrawal agreement is incorporated by Section 7A.
Yes, domestic. Yes.
It's in the Wisconsin argument, but
Yes.
that again is a given. And I'll ask you to read 2. I won't read it out.
Yes. And 3.
Provisions of this agreement referring to union law or to concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of union law. That's important, as we'll come to.
Yes.
Then you've got 4. The provisions of this agreement referring to union law or to concepts or provisions thereof shall in their implementation and application be interpreted in conformity with the relevant case law of the Court of Justice of the European Union handed down before the end of the transition period.
Yes.
And 5. The UK's judicial and administrative authorities shall have due regard to relevant case law of the Court of Justice of the EU handed down after the end of the transition period.
Yes.
And then we have Article 5, and that is headed good faith, and the appellant submits that this is another very important provision. So Article 5, good faith. The Union and the UK shall, in full mutual respect and good faith, assist each other in carrying out tasks which flow from this agreement. They shall take all appropriate measures, whether general or particular, to ensure fulfilment of the obligations arising from this agreement, and shall refrain from any measures which could jeopardise the attainment of the objectives of this agreement. This article is without prejudice to the application of union law pursuant to this agreement, in particular the principle of sincere cooperation. Well, may I take a minute to just connect that back to the Minister's letter of February 2022. That, in my submission, was flatly contrary to Article 5, good faith. In particular, the obligation to take all appropriate measures, whether general or particular. Appropriate measures.
Well,
depending
to
on
ensure
the
fulfilment of the obligations, you've got to show an obligation first. And if he doesn't comply or she doesn't comply with it, then there's a breach. But it's not all appropriate measures that people would like to make the world a better place. It is actually to fulfil the obligations.
Well, my lord, the case is not, with respect, about making the world a better place. It is about remedying the difficulties which this group of individuals had as a result of the COVID-19 pandemic. It's not about making the world a better place. It's about giving them a fair crack of the whip.
Or scrap better place and just say fulfilment of the obligations. There's got to be an obligation.
Yes. Well, the obligation is to take all appropriate measures, whether general or particular, to ensure fulfilment of the obligations. But the obligations arise in respect of ensuring that those who have or have a reasonable prospect of obtaining residence rights under the withdrawal agreement are able to do so in a real practical manner. It is about making the rights that they would have real and effective as opposed to illusory.
Yes.
So if we can go to Article 9 on 1265, and so we're now into Part 2, Citizens' Rights, Title 1, General Provisions, Article 9, Definitions, and you'll see there the definitions at A of family members.
Yes.
And I won't do the cross-referring, but that's by reference to the Citizens' Rights Directive would cover spouses and durable partners who have been facilitated.
Yes. Yes.
And then we come to Article. There are other definitions, but that's the key thing in my submission.
Yes.
Right, I stand corrected on that. It would cover spouses, but not
cover
extended family
partners.
members. So to understand further, we then go to Article 10, personal scope. And that states, without prejudice to Title 3, this part should apply to foreign persons. This is 1266.
Yes. Anything before 10.2?
Well, I'd ask you to look at 1E, family members of the persons referred to in points A to D, providing
1E, yes.
providing that they fulfill one of the following conditions.
And did that include your client or not on the wording, or is that dependent on your reading of proportionality too? It looks as if they've got to be residing in accordance with union law as a family member before the end of the transition period. And if they weren't married, they wouldn't be residing as a family member in accordance with union law before the end of the transition period.
Well, in my submission, the matter of proportionality goes not simply to the residence scheme itself, but also as an intrinsic part of that, whether an individual is within the scope or not.
So the principle of proportionality under EU law will govern the interpretation of 10(1)(e)(1).
Well, the principle
1E,
of,
sorry.
the principle of proportionality under EU law, but also under Article 18(1)(r), which addresses the administrative redress procedures against decisions under the withdrawal, decisions concerning the resident status under Article 18. We'll come to Article 18 in a minute.
Look, continuing with 10. So 10(1)(e), 10(2).
Yes, persons falling under points A and B of Article 3.2 of Directive 2004/38/EC, whose residence was facilitated by the host state in accordance with its national legislation before the end of the transition period in accordance with Article 3.2 of that directive, shall retain their right of residence in the host state in accordance with this part, provided they continue to reside in the host state thereafter.
So that is a durable partner.
Yes.
Who's been recognised under the relevant domestic law of the member state as having a domestic law right of residence, and they keep that after the specified period.
Yes. Yes.
Right. The 10(3).
Yes. Paragraph 2 shall apply to persons falling under points A and B of Article 3.2 of Directive 2004/38/EC who have applied for facilitation of entry and residence before the end of the transition period and whose residence is being facilitated by the host state in accordance with its national legislation thereafter.
On the face of it, Mr. Hawking,
Yes.
both paragraph 2 and paragraph 3 appear to be posing a question of fact. In other words, you ask a factual question, were these persons being, had they applied for facilitation of entry before the end of the transition period? Was their residence being facilitated by the host state in accordance with national legislation? You say it goes further than that, and it doesn't simply pose a factual question, but requires what might be called a normative question to be answered. In other words, that you have to read in people who should have been treated in that way.
Yes. Yes. Can I will come back to that, my lord. I've been asked to refer to Article 10(5). In the cases referred to in paragraphs 3 and 4, the host state shall undertake an extensive examination of the personal circumstances of the persons concerned and shall justify any denial of entry or residence to such persons. So, Secretary of State, as responsible for the UK's resident scheme, has that duty.
And the problem is, what happens if they don't comply with it? If they didn't, in August, September, December 2020, look at all the pieces of paper in the application and looked at the council tax bill and the water bill and everything else, and they don't do it. Because you've got a situation now where they said, you have applied, but we're not going to facilitate your residence in accordance with national law, and it may be that their reasoning is flawed because they haven't looked at everything. Maybe that if they had looked at everything, they might still have said, it's not durable, it is a relationship, it's not durable, we don't know. So then you have to appeal it, don't you? And if you don't appeal it, the problem is that in breach of their rules, they reached a decision, but the fact of the matter is, that's never been corrected. That's the question that my Lord Justice Singh asked this morning. Don't we have to proceed on the fact that, rightly or wrongly, a decision was taken not to facilitate your client's residence under national law? And indeed, there's never been a grant of
No.
residence under national law. He's always been, as a matter of national law, here unlawfully.
The matter of facilitation has not been looked at. That's the situation under the withdrawal agreement. That's the situation under Article 10(3).
Well,
And
there was an application, we know that. There's a document with application on it, and there are arguments about whether it was an application under one thing or should have been treated as an application under another thing. And there is a document saying that application is refused. We know that. So when you say the matter of facilitation has not been looked at, what I'm trying to understand is, does that mean, although it's been refused, it was potentially open to challenge it on the grounds that they hadn't looked at relevant matters, or whether there's something else that you're saying? And I think you've got to address at some stage the existence of a document which says the application is refused, which hasn't been appealed.
Well, my lord, could I deal with it in this way at this point? We've already looked at Article 5, good faith, and the third subparagraph. Your lordship did ask me what obligations was I referring to when I referred to the second subparagraph of Article 5. They shall take all appropriate measures, whether general or particular, to ensure fulfilment of the obligations arising from this agreement, and shall refrain from any measures which could jeopardise the attainment of the objectives of this agreement. That more than encompasses the Secretary of State considering an application made under Appendix EU, in particular by the specified date, not necessarily with evidence included, although there was in the appellant's case, but certainly an application under Appendix EU should, in my submission, in light of Article 5, in light of the difficulties with regard to COVID and all the other matters I've already mentioned, and in light of the fact that the specified date is approaching. Of course, when the appellant made his application, it was August 2020, and yet the decision was not made until March 2021. But in terms of what are the obligations that the Secretary of State should take all appropriate measures to fulfil, that in my submission is a prime example. And
she should have considered that not simply as an application for the grant of a new resident status. She should have treated that as an application
Yes.
for the resident status under domestic law that she would have granted had she been satisfied that it was a durable relationship,
Yes.
namely a residence card and Article 8.
Yes.
And she didn't, so what happens next? She refused it.
Well, Article 10(5), the host state's required to undertake an extensive examination of the personal circumstances of the persons concerned. That's not happened. That's an obligation. That's an obligation on which Article 5 good faith bites.
Does your submission give any effect to the words "in accordance with its national legislation" in Article 10, paragraph 3? Or can I ask another question, same question, another way? On your submission, what is the legal significance of the phrase "in accordance with its national legislation"?
Yes, well, in the appellant's case, to give a concrete example, made his application. It's clear what he was saying. It was clear that he provided evidence. And as we've seen from the chronology, he was issued on the 19th of October 2020 a certificate of application. We do have a copy of that. We have that document at 10 to 11 of the agreed supplementary bundle. It's a certificate of application.
Yes.
And that's the one that has to be issued under Article 18 when you applied for the new status, rather than an application for facilitation under the old directive.
Well, in my submission, if that's read in a, well, in my submission, that covers the appellant's case. He made an application under the Secretary of State's Immigration Rules. It was pending a decision
Yes.
from when made. Well, your lordships have the dates already,
Yes.
but it was pending a decision for a period of around 6 months, crossing over the critical
Yes.
specified date. And in my submission, the issuing of the certificate of application is more than sufficient. In fact, even if it hadn't been issued, the fact is the appellant had made an application and it was pending crossing the 31st December 2020.
So, answer my Lord's question about what the meaning of "in accordance with its national legislation" is, or what the effect of it is. Is the effect that national legislation has to incorporate what is required under paragraph 5? Is that what you're saying?
In my submission, national legislation can be broadly looked at as the state's statutory law
Yes,
or immigration rules or regulations.
but it has to be it has to be sufficient to give proper effect to the obligations arising under the terms of the withdrawal agreement.
Well, the Secretary, yes, the Secretary of State's processes have to be sufficient to fulfil that obligation.
Right, yes.
The problem that you've got is Ms. Smith will say this. Well, there is a process. It's called applying for a residence card under Article 8 and Regulation 8. It's not the process of applying for a new residence status, a different residence status, which is aimed to translate something you've already got into something new. And she's saying, if you apply for a new status, the first question is, well, where's the proof you've got the old status? That's what she says.
Well, in the particular and singular circumstances of 2020, in my submission,
You should still read, or is capable of reading, so an application made, no matter how you describe it, if it's clear that what the person wants is to stay in the United Kingdom with the woman he's living with, then they've got to assess that.
yes,
But what happens if they make a mistake and they refuse the application and nothing happens? At that stage, you've had an application. There may or may not have been a breach of national law read in context with Article 5 and Article 10.5. But the fact of the matter is, as at whenever the date was, March 2021, he had an application which had been determined. Rightly or wrongly, it hadn't been facilitated in the sense of no national residence card or the letter in lieu of a national residence card had been granted. And that was never appealed. And I'm still troubled by what the answer is to my Lord's question is, how should we proceed on this appeal, trying to breathe life into an earlier application, which was done and dusted, rightly or wrongly, in March 2021. And I'm still worried about that, I'm afraid. But I suppose your answer is the substance of facilitation hasn't been looked at, and that's the end of it.
yeah, yes,
So could he
indeed.
apply for judicial review tomorrow? And say, well, you still haven't dealt with my application properly, please deal with it. Or in 6 years' time.
Well, my Lord, paragraph 3 simply requires an application for facilitation before the end of the transition period,
Yeah.
and facilitation thereafter.
Yeah, and there hasn't been facilitation thereafter.
Well,
It's been refused. The facilitation would have been a residence card.
it was pending a decision. It was an application under national legislation. It was pending a decision.
Okay.
As
It's got to be read as an application for a residence card, and there's never been a decision on whether to grant a residence card, and therefore it's still outstanding.
Yes, well, for the purposes of Article 10.
So we allow the appeal, and the Secretary of State must decide whether or not she thinks it was sufficiently durable as at the latest, the 31st of December 2020.
Yes. My Lord, can I take to Article 18?
Yes.
We've already looked at Article 18.1. If
And we've now moved from Title 1 to Title 2, though, have we?
that is right, yes.
Because Title 2 has rights and obligations, and there's lots of rights of residence there for people. They, of course, are people who had rights under the old EU law. They're the EU nationals who exercise their rights. They're people who've got rights of permanent residence and so on. So you've got all those rights building up.
Yes.
Nothing there about extended family members, because of course they wouldn't have rights to reside under EU law. That would come from the exercise of national discretion, and then you get to 18, where you are now.
Yes. So this sets out the detailed conditions if a state opts to create a new residence scheme.
Yes.
I noticed in paragraph 1b, there's the reference to the time limit, which we saw earlier.
Yes.
The deadline for submitting the application shall be not less than 6 months from the end of the transition period. On the face of it, Mr. Hawking, that looks like a very clear, express, fixed deadline. But does your submission lead to the consequence that sometimes these apparently fixed, clear, express deadlines don't really mean what they say, because there might be a very good reason why you couldn't comply? You couldn't submit your application within that 6 months because, for example, let's say the coronavirus pandemic was in full flow just around the time of the 6 month deadline.
Well, my lord, the dead D
Right.
covers that.
Well, that shows that when the framers of this treaty wanted to
Yes.
extend a deadline,
Yes.
they made express provision for it.
Yes.
But otherwise, it means what it says.
Well,
Or is that wrong?
my lord, looking at a treaty, there's a context of EU law and principles and jurisprudence, and a lot of that's referenced in the skeleton. There's also the Vienna Convention on the interpretation of treaties, and I mean, at this point it may be helpful to just go to that.
Well, sorry, I didn't want you to take. You
Well,
must
no,
make your submissions out of turn. please.
My lord, it's not a difficulty.
Is there anything else you want us to look at in the withdrawal agreement first? We've looked at 18. 18,
Yes.
I thought 18.1r.
Yes.
Are you taking us to?
Well,
You
there
want to
was-
show us
there-
quite a lot in 18, I think.
Yeah,
You want
there
to
is a
show
lot.
us that this is to apply for a new residence status,
Yes. Yes.
and the document evidencing that status. That's the
Yes.
first thing, it's the new status.
Yes.
Then although it talks about, you'll want to say, I'm sure, that although it talks about Union citizens or United Kingdom nationals, their respective family members who don't include durable partners, it does include people who are other persons, and that must be a reference to extended family members. And although those people don't reside in the United Kingdom in accordance with the conditions set out in this title, Title 2, you will want to submit, I'm sure, that that's because they don't actually have rights to reside under EU law, and the intention must have been under Article 18 that those who had been at least recognised or had applied for and had undetermined applications for extended family status prior to the 31st of December should, if that extended status is recognised, be continued to have it afterwards. So you'll say all of that, I'm sure, about Article 18(1) in due course, and you'll want to say that it obviously covers extended family members, because if you look at L, the documents that you can require is the residence card.
Yes.
So you'll have said all of that before you get to R. But don't let me stop you saying it.
Well, my lord, I'll gratefully accept the shortcuts
So that all helps you.
that you've offered, we have R, but before that we get to O, and again, this is in my submission an Article 5 good faith obligation that requires all appropriate measures. So the competent authorities of the host state shall help the applicants prove their eligibility and avoid any errors or omissions in their applications, they shall give the applicants the opportunity to furnish supplementary evidence and to correct any deficiencies, errors or omissions.
Yes.
So that's, in my submission,
Well, I understand that, obviously.
very...
But does that enable a court or tribunal in this country to disapply the apparently fixed end of the transition period because the country was in the throes of the pandemic?
Well, my lord, it would be my submission that on a layperson's view of the case, it would be a very harsh and unreasonable result if that was so. I don't say that the moral dimension and the weight of the problem and the numbers involved is in and of itself decisive, but it's a consideration. But can I take you to the Vienna Convention? And that is tab 50. So this was referenced in the upper tribunal decision, of course.
Yes.
So you have, in actual fact, I've handed up the preceding page, including Article 26.
Thank you.
That's just been missed out by an oversight. So, Article 26. Actus sunt servanda, every treaty in force is binding upon the parties, so it must be performed by them in good faith.
Yes.
Of course, Article 5 in the withdrawal agreement is very expansive on that.
Yes.
You have Article 31.
Yes.
1. A treaty should be interpreted in good faith, in accordance with the ordinary meanings given to the terms of the treaty, in their context, and in the light of its object and purpose. The context is regularising the status of EU citizens, family members, and so forth. The context is also the backdrop of EU law rights that those EU citizens would have had. And the object and purpose is what we have in the recitals and preliminary articles in the withdrawal agreement. But then we also have Article 32.
Yes.
So I'll just give you a moment on that.
Yes.
So Article 32, supplementary means of interpretation. The course may be had for supplementary means of interpretation, including the preparatory work of the treaty. That's not being put forward. And the circumstances of its conclusion, in order to confirm the meaning resulting from the application of Article 31, or to determine the meaning when the interpretation, according to Article 31, A, leaves the meaning ambiguous or obscure, or B, leads to a result which is manifestly absurd or unreasonable. Well, my lord, the appellant's submission is simply this. It's part of the undisputed chronology of this case, that the withdrawal agreement was concluded before the COVID-19 pandemic became an issue. I'm not perhaps medically qualified or otherwise qualified to say exactly when it was known about in its embryonic form.
Understand the point.
But,
yes.
But the point is, the COVID-19 pandemic was simply not an issue
Yes.
in October 2019. So that is clearly and indisputably a circumstance of the conclusion of the agreement.
Yes.
If, in my submission, if a hardline, folded arms, tough luck approach is taken to these cases, as the Secretary of State has, it is not a question necessarily of the interpretation being ambiguous or obscure,
No.
but it is a question of Article 32B territory. leading to a result which is manifestly absurd or unreasonable.
Okay.
So, in my submission, that supplementary means of interpretation, Article 32, to be precise, Article 32 with an emphasis on B, that is a judicial tool in my submission, a proper means of looking at the appellant's case and the cohort with a view to interpreting, if need be, the scope provisions in Article 10 and the detailed appeal provision, the detailed residence scheme conditions in Article 18. Because it's, in my submission, must be right to not allow the disruption of the COVID-19 pandemic in that critical implementation period, the transitional period, to confound the expectations of EU citizens and the other affected individuals, because that would be, because otherwise the result would be absurd or unreasonable if that couldn't be factored in some way. So, for example, such a purposive approach would entail considering Article 10 well, may I put the point generally, because we've gone through the detail of Article 10, but it would...
Well, how would you say Article 10 should be interpreted in the light of your submission with respect to Article 30? Someone who had intended to and taken steps to marry an EU citizen in 2020, for example, but was unable to do so because of COVID, should be treated as a family member, as their spouse.
Well, just look at how that would work. That means taking 10(1)(e) and changing the wording quite a lot, wouldn't it? Family members who reside in the host state in accordance with union law, or would have done so for some period afterwards until they're able to marry. And you bear in mind this doesn't cover just family members wanting to marry people resident in the United Kingdom. This applies to UK nationals in all other 27 member states who will be governed by this agreement as well. And the question is, what about them? We know nothing about whether or not they, in Sweden, for example, they didn't have lockdown. In other countries, they did have lockdowns, but we don't know the periods when. We don't know what the rules on marriage were. We don't know whether the European Union would have said, you wanted a divorce, you live with the consequences. So how can we begin to speculate how this provision would have been understood by all 28 signatories, given that this has got to be a rule for everyone?
Well,
or do they only apply to UK nationals? This is just about allowing people who are in the Union. There's no way in which British nationals in Slovenia would be able to rely on this, because the personal scope is just about Union citizens who've exercised the right to reside in United Kingdom law. Is that the answer to that?
Well, my lord, it's a question. It's a question for this court. Of course, the court has the option of making a reference.
Yeah, but if we don't, what's the answer, though? Does this only give us rights, other people rights in the United Kingdom? Or
Well, my lord,
I know it's 11B. It covers the United Kingdom nationals who exercise their right to reside in a member state. So it covers everyone. So we'd have to be sure the 10(1)(e)(1) was to be interpreted in the way that you applied for all member states. And what's the cut-off point? When the last coronavirus restriction was lifted in the last member state?
well, there would have been different responses by different member states, no doubt. But in my submission, the court's task is to consider the appellant's situation within the UK and to interpret the rights under the withdrawal agreement in light of that.
Thank you.
But in any event, there is the consideration of Article 10(3), and you have the appellant submissions about that.
Does Article 10(3) require any reinterpretation in accordance with Article 32B of the Vienna Convention, which you showed us? Just trying to understand what, if any, interpretation you're asking us to give paragraph 3, other than its ordinary meaning.
Well, my lord, you have my submissions on that. I don't think perhaps that requires such a such an approach for the reasons that I've already said. But my lord, I understand the point that my Lord Justice Lewis has raised regarding other states and their approach, but if one looks, for example, at Article 13(4), so Article 13(4), page 1267, Article 13 is dealing with residence rights, and 4 on page 1268 states, the host state may not impose any limitations or conditions for obtaining, retaining or losing residence rights on the persons referred to in paragraphs 1, 2 and 3, other than those provided for in this title. There should be no discretion in applying the limitations and conditions provided for in this title, other than in favour of the person concerned. So, my Lord, the reality is that under Article 13.4, the withdrawal agreement specifically refers to discretion in the context of a host state not imposing limitations or conditions for obtaining, retaining or losing residence rights. That covers the appellant's case if he's not able to...
Well, he's not in paragraph 1, 2 or 3, is he though? I thought this was just the people who had rights under EU law and not the Article 3.2 directive extended family members. And I thought this was saying, but you'll correct me if I'm wrong, that when you've got rights of residence under EU law, because you're a union citizen working here or a family member in the narrow sense, you can't impose more rigid restrictions than provided by in Article 30, or you can be, but you can be more generous. It doesn't seem to help the 10.3 people. What's going on as well about titles, because the extended family members aren't in this title.
Well, it's an important feature of the withdrawal agreement that there's reference in it to discretion in favour of the person concerned. And in my submission, Article 13.4 is looking at the person concerned. That's a person that is applying for status likely under a declaratory scheme. Article 18, 1 as follows, deals with the constitutive residence scheme. If there's a declaratory scheme, i.e. the EU, what would be British citizens, for example, in another member state, they would, they and their family members would be able to just simply continue living in that member state. But if a point arose at which one of them needed a document, then Article 13.4 covers that situation. The person concerned is someone applying for status under Article 13, likely under the declaratory schemes. And Article 13.4 stipulates that there can only be discretion in favour of the person concerned. So, in my submission, when states, other member states are making decisions about status rights under the withdrawal agreement, they're doing so on an individual basis in terms of the situation in those states against the backdrop of Article 13.4 that there is discretion, and as a matter of as a matter of process, there's always a residual discretion in decision-making processes. There's always an element that comes down to the decision maker in my submission. So that in my submission deals with the court's concern about the approach to interpreting Article 10 scope and whether someone is entitled to status under Article 18.1.
Thank you. I think that's probably convenient. How are we doing for time in respect of your submissions?
My Lord, I would think not less than another hour, perhaps. I mean, I've gone through the substantial materials which set the context.
Thank you.
If it's any help, my Lord, the timetable that we've agreed provides for effectively me finishing up today,
right,
Miss Ward having the first half an hour tomorrow, and then on that basis, my learned friend Miss Smythe thinks she'll have adequate time to respond to the arguments, leaving a bit of time for Mr. Hawking to reply.
Thank you very much. Thank you. So we'll start again at 2:05.
All right.